All right. I'm here with Craige Thompson, and he is the managing principal at Thompson Patent Law. How's it going, Craig?
Hi, Steve. Thank you so much for your time.
Yeah. Yeah. This is going to be a really fun tactical episode. And I wanted to first start with your background. How did you get into this space?
Well, my quest really began with patent, or not patent protection, but business protection, when I was having coffee with my dad's best friend. And he was telling me what happened to my dad's business around his kitchen table after my dad had passed away. And I grew up in my dad's business. It was a pharmacy. It was an independent pharmacy, and he was doing better than the Walgreens around the corner at the time in the little town of Fond du Lac, Wisconsin. And what he did is he invented some software. Was back in the 70s and early 80s was blue ocean stuff. And he developed software that would manage and make the pharmacy a lot more efficient. And he got all 100% of the contracts for all the nursing homes in our county, and it was taken off. And this was absolutely. But he spent, like, in today's dollars, like close to $500,000 in consultants and software development and hardware, which was much bigger back then. And it all comes collapsing down when Congress changed one little law of the Medicare, Act or something. And Peter's explaining to me what happened, because I didn't understand. I was in high school. What happened to my dad's business? Everything was going amazing, and then it all went away. I think it broke his spirit. He passed away at a very young age, and broken home, my sister and I. It's had a lot of personal impact, and that's led to me being on this lifelong quest to go through first an engineer, then a patent attorney. Now I just finished my MBA, law, engineering, business, to help entrepreneurs not have to go through that with their families, with their employees, with their customers. And so really our mission is my mission is now just to help business builders get rewarded for their innovations so that their solutions can bless more lives. That we really feel strongly because of my personal experience. I can't help my dad, but I have and am helping hundreds, if not thousands of entrepreneurs who are going through that.
Nice. Very nice. I think it's one of those underrepresented aspects of getting prepared for something like an exit or a fundraise. It could be a lot of different components that people don't think about, but patents isn't one of the top ones on the list that a lot of people sort of skirt over, in my experience. And as a patent holder myself, I think it was
Oh,
really exciting to jump on this episode. And I wanted to start with, what types of kind of important leverage does this give you? Like what motivational pieces can you share for listeners about why patents are important for valuations when you're going into an exit, for example, when they're going into those conversations?
yeah. So of course, an exit can be based on a multiple of EBITDA, right? And EBITDA is profit. And so if your profit, if a patent can protect one or more streams of income, and it's almost like an insurance of protecting and defending that profit stream, that goes into the multiplied by your multiple at exit. So I mean, we're building EBITDA. It's a patent should be, in my view. I'm a bit of a contrarian. It's not conventional. Most patent attorneys aren't really thinking about business. They're just thinking about patents. So my strong position is that patents should be an asset on your balance sheet. An asset should put cash in your pocket, and shouldn't just be sitting on the shelf. It should be really an active asset that is protecting some sort of revenue stream and profit, and getting that EBITDA. So that's really important, I believe, at exit. So that's really and recently I've done just finished my MBA in December, and I got reacquainted with Porter's five forces. Are you familiar with Porter's
A little
five
bit, yeah.
forces? Well, I did a little thinking about it, and it occurred to me, and I don't know if anybody else has ever really delved into this, but it's my little piece of insight is the Porter's five forces really defines, and this goes to exit and valuation. When you have a patent, it actually solves for all five of Porter's five forces. If you think about it, there's in the competitive landscape, and there's the sort of your existing rivalry in the center. It gives you obviously the ability to have a monopoly against your competitors, your existing rivals. A patent can also protect against new entrants, which is another one of the Porter's five forces. If you have a patent on a specific, what I call a commercially valuable choke point, and they can't come in and they see you're making money and then they try to copycat you and they try to jump in. If you've got a properly engineered patent, not every patent does this, and there's specific ways that we do this, but if you can stop the copycats from coming in, well, that blocks new entrants. And then, design arounds, again, if you don't have a properly designed, engineered patent, it's not going to protect you against design arounds. And that's a big fear of founders is like, well, patent, it's easy to design around. Well, actually, if you do it correctly, a lot of patents can be done that way, or you shouldn't be doing the patent at all. We talk 30% of people out of getting patents. But if you can protect against really practical design arounds, and it's really expensive for competitors to come up with some alternative design around, which is possible, not in every case, but in a lot of cases, it is possible. So that's another, and then the other one is, the other two Porter five forces are leverage against customers. Well, if you're the only game in town, if you have basically a monopoly for 20 years during the patent term, well, your customers don't have leverage over you, so you can charge monopolistic pricing. You can get rewarded, and you don't have pricing pressure. And then finally, and this is kind of a big one, was when a lot of entrepreneurs or founders go to manufacturers or their vendors or suppliers, and they share their idea, and they have to have it manufactured or coded or engineered. If they have that patent protection, or if they don't have the patent protection, sometimes this has happened to a lot of people. The manufacturers will take that idea and run with it and say, well, you didn't have it patented. Thanks for the idea. We don't need you now. So it actually solves for potentially all five of Porter's five forces, which gives you competitive advantage and helps you keep your prices up, which helps with that EBITDA. Which is so important at exit.
Yeah, and I think that when it comes to having a moat and a lot of the different aspects of, especially software businesses, in my experience, a lot of people overlook patents. But over the last probably 5 or 6 years, I've come across a lot of people talking about it. And I think that there's a more interesting and compelling space for it now with AI and things like that coming out, and that was why I was very interested in having this conversation around the tactical aspects and what the kind of value that an entrepreneur could place on their business for getting a patent. And what would you say are like the sort of the pieces that you can do to weigh the actual impact for their business? Like, is it a dollar value when somebody's saying, I need to get a patent because I'm worried about the competition, I need to get a patent because it's going to increase my valuation? What do you see as like the sort of most important driver that people do this?
Well, I just answer that, Steve, with first principles of, whether it's an AI patent, which we've gotten, or it was a medical device or software or electrical, mechanical, whatever it is, and I've gotten thousands of patents in all these areas. So it comes down to what I call the 7-step strategic patent assessment that you should do before you start any patent. Okay, and this is all outlined in my book, and your audience can get an executive summary version of this if you want, just as a resource, and get more detail because we don't have enough time to go through it all. But on our website, in our resources area, there's an executive summary of my book, which was a #1 bestseller on Amazon, called Patent Offense. And it really boils down to, should you get a patent, or what's the value, and is the patent right for a particular idea? And that there's first 3 questions are all patent questions, and then there's 4 business questions. That's the 7 steps, and they're very straightforward. And most people only do the first step. Some people do the second, which is the prior art search, and they may or may not do it as well as it needs to be done. But the key is the 3rd step. That unlocks everything, and that's my big. If I contributed anything to the world, when I was an engineer for 10 years, I didn't invent anything, but I've invented a lot of processes for patents. And this is if I feel like I contributed something to the world, is that 3rd step, what I call the point of novelty assessment, which is boiling it down. What do you have 3 or 4 features typically that are old, but when you combine them in a new way, whether it's an algorithm or a widget or a circuit, or a chip, or some software algorithm. When you take those 3 or 4 elements and combine them in a new and non-obvious way, you can actually protect that with a patent, and that's what I call a point of novelty. If you can articulate that in a single sentence, which is what a patent claim is, right? A single sentence begins with a capital letter, ends in a period. If everybody you can write one sentence that this is my idea, boiled down, stripped off of all the extras, and boiled down to the minimum necessary and sufficient elements, then you can, everybody around the table, whether technical, non-technical, marketing, executive, they can all understand, yeah, we want to get a patent on that. If we can get a patent on that's what I want, these 3 or 4 features. And then you can ask the 4 business questions. Once you know what, if anything, do I think I can get a patent on, then you can ask the 4 business questions. And that is, does that, what I can protect, actually align with a commercially valuable choke point? Because if they're not aligned, if what you can protect is not really protecting that commercially valuable choke point, then someone can design around your claim and still get to that commercially valuable choke point. That's that design around issue we talked about. Mm-hmm. But if they are aligned, when that happens, it's like, peanut butter and chocolate, magic happens. 1 + 1 is 3. And that's when a patent really makes sense. But if that's not the case, then you shouldn't get a patent. And we talk people out of getting a patent 30% of the time after the first hour that we meet them. And that's been true for the last 10 years, because it just doesn't make sense to patent every idea that sounds good. Maybe a great product, but it from a patent standpoint, it needs to not only be patentable, but it also needs to be a business asset that is actually going to make my minimum requirement, if you want to quantify it, is at least a minimum of 100 times ROI of what it costs to get a patent. You should be able to protect at least 100 times that. And what does that translate to? It translates to at least $2 million or above of gross profit over 3 to 4 years. That's my rule of thumb, is if you are talking about the values, the gross profit that you can get year 1 plus year 2 plus year 3 plus year 4, if you can project that out, not in a most optimistic case, not in a most pessimistic, but a most likely business case, if that adds up to more than $2 million, then you should consider a patent if you've got that point of novelty and alignment. So those are some of the key ingredients, and I go into this in depth in my book. If you can get the free resource, the free executive summary on our website, if you'd like, in more detail.
Got it. 2 million. Okay. That's a good, I like that tangible number. That's a solid tangible number over a few years. And I think that's a good framework to start with. What are some mistakes? That's my favorite question to always ask here, is misconceptions and mistakes in the same kind of area here that you've seen over the last few years with entrepreneurs coming into the patenting process.
Well, there's a couple that I'd like people to, know about. One is the second most common thing people say to me is, I've searched everywhere and there's nothing else out there like that. They almost say that almost word for word. They come to us and they say, I already searched everything. There's nothing else out there like that. And then we do a search. And then we find only 100% of the time so far, it may happen someday, but only 100% of the time we find like at least one thing that, even though they're the expert in the area, they got a PhD in this area, and they're know much more. They've been searching it for years. When we go through this process, it takes an hour. We always find something, and it's like, oh, I didn't realize that there was something that close. Now we have to have a real conversation. Is this prior art? Is it that's going to get in the way of getting a patent? If so, put your wallet away. Don't get a patent. If it's there, okay, now it's there. It's like a landmine. We need to deal with it. How are we going to get around through the minefield of prior art? With now we know we have a map of the minefield. Now we can deal with it and decide. Well, if we adjust this here, and oftentimes what we find when we do this process, and this is kind of working in step 2 of my 7 steps, we're finding that actually they say, well, I could do this and I could do that, and it's sort of engineering on the fly sometimes, and it actually improves their idea. They're actually finding that, because we're all engineers, we're patent attorneys, but we're first and foremost engineers before that. And so we're helping them like get the technical and shape it. And sometimes some beautiful things happen. Can't guarantee that, but it does happen. And it's really wonderful when it does. And they actually realize that there's more there, that it just kind of gives them that push to see, oh, if this is out there, I could do that. And I could change this over there, and no one's thought of that yet. It's even better. So that can happen, and that happens fairly regularly. But if not, we find, oh, there's something here that's actually really close, and what we could patent would be so small, we wouldn't have that alignment, and don't get a patent.
Got it. And I think that there's a couple different ways of thinking of an exit, and I think that patent licensing is a unique route that we could consider here in this conversation. For everybody listening, I've met dozens of entrepreneurs who have a stockpile of trademarks, patents, things like that you license out, and it generates income long term. And what's your experience been with that in terms of people, whether they're selling or licensing their IP? How should people think about this, and how should they approach it?
Yeah. So monetization strategies is step 6 in my book, or 5 or 6. It's one of the two. I think it's step 6. The other one's profit strategies. So monetization strategy is my favorite. It's the fun topic, right? So licensing is something that I think there's not enough creativity in when people approach it, and there's a lot of opportunity for win-win. And there's a couple of things tactically I'd like to offer your audience, that every license that I like to do, if possible, I use multiple field of use licensing. If you're familiar with that. And so that you can carve out a single patent, the rights of a single patent. It's sort of like, think of real property. Intellectual property is similar to real property in the sense that you can subdivide it, and expensive things come in small packages. So we can subdivide your patent rights into smaller slices and license out, to different industries, different licensees. Some might be multiple. So from a single patent, you can get multiple potential licensing deals in perhaps different industries, different markets, different geographical areas. And when you exit, you can consider that you're selling the patent with the business, with the purchase agreement, but you can also do a grant back in a field of use strategy where you're going to keep it in a small niche that the buyer doesn't really care about. So they can get the patent, they own it. Now you started with the patent, you end up with a license and a bunch of cash from selling the business, but you can still pursue in a limited by contract. That's what a multiple field of use license is a contract. You have the ability to continue doing what you're doing, and it's not interfering with the buyer. So you can really monetize it more fully, squeeze more juice out of it.
Super cool. Yeah, I've been curious about that because I've heard of people doing it, but that's the first real sort of walkthrough that I've heard of
It's not
how it could
difficult.
work.
It's
So
not
field
difficult.
of use, really interesting. Okay. And when it comes to negotiating that, let's say a licensing deal, I'm
Mhm.
a entrepreneur operating, I go through the process of getting a patent. What does that negotiation look like, and what have you seen kind of work with the field of use in mind?
Well, I've actually there's a particular one I can talk about. It's public. That years ago there was actually I used a patent license to solve an employment dispute of all things, and
Huh.
this is a lesson for founders and people who are thinking about exiting. Having IP clearly, properly owned by the company, and also making sure that any ideas that are floating around in your engineers' heads or your technical people's heads, that they don't walk out the door and this happens a lot. I mean, I'm seeing a lot of activity where people with technical knowledge who have more technical knowledge than the founders owners, they're saying, hey, I'm going to go out and do this on my own, and then that creates a potential litigious environment for employment disputes. Like, hey, was that trade secret misappropriation? Who owns the rights to the inventions during the employment and everything? So employment agreements are important, and you got to start thinking about that early. Making sure that that you as the founder own all the IP, and you're
Hmm.
aware of and mind for IP that may be floating around that could walk out the door by an engineer who sees opportunity, for example. So
Hmm.
so that's one example of that is a case I was involved in Minnesota where I worked with an employment lawyer, and there was an engineer who left the company, and they said, "Oh, that's fine, go ahead." He said, "This is what I'm going to do. I'm going to go do this," and the company said, "Fine, go ahead." And then so he went off and started this entrepreneurial adventure with this technology that he thought of while he was employed, and then they changed their mind. There was nothing in writing. This is before I got involved. And they changed their mind, said, no, no, we want that technology back because I see you're going to make money with it. So we want it. It's ours because you invented it while you were our employee. And big lawsuit. And the guy's trying to start his business and, starts off with a, huge lawsuit. And the solution, I said, well, it's technology. Let's take the patent application, which I didn't write, but I came in and said, let's look, let's solve this with a field of use license, where he all the entrepreneur needed was in the athletic, recreational, sports direction. So his field was athletics, and he wanted to license this to Nike, right? But the other company, he didn't want to just medical. We could license this to hospitals, doctors, clinics, and they saw that as a potential market for this technology, and they wanted that. And so, okay, these are we can settle this lawsuit. We get the rights to medical field of use. You get the rights to non-medical field of use. It's one sentence at the back of in an attachment to the license agreement. It defines the field of use in one sentence. It's not complicated. And it settled the lawsuit, and he was able to go on and succeed from there.
Nice. Got it. Okay. It's a good.
Creativity.
Yeah, yeah, that's creative. Very creative. I like that. So that takes us to the finale. Knowing what you know now, what would you tell Craig 10 years ago?
Well, I think in thinking about that, I think it's really coming back to the experience I had with my dad and my family and everything, and how I so much believe in entrepreneurs. I think it would boil down to this: is it's much better to live on the collaborative plane than the competitive plane.
Hmm. Well said. Well said. Well, those are all the questions. Where can people learn more about how to start with a patent, learn more about patenting?
Yeah, well, we're doing a one patent away challenge periodically on a monthly basis. So If you're interested in, getting a little bit of a deeper dive, we do a 1 hour session on patents, 1 hour on, protecting your brand, and 1 hour on monetization over 3 days with worksheets and some bonuses for doing the homework. That's at onepatentaway.thompsonpatentlaw.com. And it's called the One Patent Away Challenge, and you can get those resources at thompsonpatentlaw.com, under the resources tab, and you can get an executive copy of my book, so you can read more about the 7 steps. And you really should do that before you start any patent, those 7 steps, to make sure it's right for you.
Very cool. Very cool. Well, this was super enlightening. I'm really glad that we could jump on, just because this is an area that I've been really curious about, and I got a patent when I was in college, and I've always been very interested in how this type of thing could benefit, like an evaluation and monetization long-term for entrepreneurs. So thank you so much for coming on and sharing all your wisdom, Craige.
Thank you, Steve.